How does an individual get a guardian appointed? Hi, my name is Mike Rutkowski, estate planning, elder law, and probate attorney at the Rutkowski Law Firm. There's a lot that goes into having another person be able to legally make decisions for another individual. And so we're assuming here that someone doesn't have powers of attorney, because if you have a medical and financial power of attorney, you typically do not need to get a guardianship in place. A guardianship is a legal order that allows an individual to make decisions for another person. Now, there's terms like guardian and conservator. Difference between the two: a guardian takes care of the physical well-being of an individual. Conservator takes care of the financial side. Typically, a court is going to appoint one person to handle both, but there are situations that they might divide those responsibilities amongst two individuals. They also might get the court involved and have a court-appointed attorney act as conservator and another person as guardian. There's a lot of different scenarios depending on the relationship, the dynamics of the family. There's a lot that goes into it. But so let's assume, for conversation's sake, that there is no power of attorney in place. A person has been deemed unable to make their own decisions, so we need someone else to help them, and now we have to go down the guardianship route. And so there are court forms that an individual is going to have to fill out. A lot of times you're working with an attorney to do this, and there's going to be a hearing. Meanwhile, once the court forms are filed, the appropriate court forms in your state, again, I'm a Michigan attorney, but it is very similar across the country. You file the court documents, and then there's going to have to be a notice that's filed with all interested parties. Anyone who should know about this should know about it. Everyone has an opportunity to come into court and raise their hand and say why they should be appointed guardian, or maybe contest the fact that a guardian is needed. Typically, when a proper guardianship is filed, the court is going to appoint a guardian ad litem. This is also referred to as a GAL. This person is the eyes and the ears of the court. They're going to go out and meet with the interested parties. They're going to meet with the ward, the individual who needs the help, to assess and make a recommendation to the court as to, one, does the person need a guardian? And two, who should that guardian be? They're going to ask a lot of questions. They'll work with any of the attorneys involved, and they will be present at that hearing, the hearing that must happen regarding the appointment of guardianship. And at that time, they're going to make a recommendation to the judge. The judge is going to heavily lean on their recommendation because they've done all the hard work of meeting with the family, reviewing doctor's records if there are any. If there's any question as to whether a guardian is needed, typically a court is going to have an independent medical examination done. They're going to send the person out to a person who specializes in this to determine whether a guardian is needed. Once the court gets that report back, they're going to make a determination of, first, is a guardian needed? And then two, they're going to who should be appointed as that guardian. Now, typically, if there's a spouse, the spouse could be appointed, kids could be appointed. There's a lot of different factors. There's usually a statute that says an order of who should be appointed. In every state, it's a little bit different, but they're going to look at that. They're going to look at all the facts surrounding what is going on, what's the relationship, or, is who's acting in the best interest of that person, and the judge is then going to award the guardianship. Now, there's a lot of things that can go sideways in a guardianship hearing. If the individual does not want a guardian, which is a lot of times the case, even though they're incapacitated, they could say, I'm fine, I don't want any help. If that's the case, then they are entitled to come to court to state their own case. So these guardianship hearings can sometimes be a little bit more complicated than one might think before getting appointed. I'm working with a family right now where we're on the third hearing because we can't determine who should be the guardian. The individual who needs the ward, who needs the help, does not want a guardian. So there's a lot of factors that we have to work through. This could have all been avoided had we done proper estate planning during the person's life, because when the person had the capacity to make these decisions, they could have made the choices for themselves. Who's going to make the decisions for them? What authority do they have to make decisions about? You can decide all of this while you have the capacity and keep this all out of court. Keeping things out of court saves everyone time and money, and even more importantly, it keeps the family from fighting over these things because they were all determined in advance. If you have questions about powers of attorney, guardianships, conservatorships, give the Rutkowski Law Firm a call, 248-792-9193, or check out our website, rutkowskilawfirm.com. That's RUTKOWSKI lawfirm.com. On the site, we have a bunch of great downloadable resources. Check those out, and hopefully they can help you through this process. Have a great day.